As we conclude this module on commercial real estate, it is essential to examine the regulatory framework that governs how land and property can be used, developed, and transferred. Financial literacy and transactional expertise are vital, but without a strong understanding of water rights, zoning classifications, and regulatory oversight, a licensee cannot competently guide clients through Arizona's commercial property landscape. These regulations are deeply rooted in statutory law, administrative code, and constitutional principles designed to promote responsible growth, protect resources, and ensure lawful land use. Arizona's unique environment makes water rights one of the most critical regulatory issues in commercial real estate. Under the Arizona Groundwater Management Act of 1980, codified in ARS Title 45, the state created active management areas, AMAs, and irrigation non-expansion areas, INAs, to protect groundwater resources from overuse. In AMAs, such as Phoenix, Tucson, and Prescott, developers must demonstrate an assured water supply, AWS, before subdividing land or issuing building permits per ARS. Paragraph 45, 465.05. This requirement ensures that developments have a 100-year guaranteed water supply that is physically, legally, and continuously available. For instance, if a developer plans to build a new industrial park in the Phoenix AMA, they must obtain an AWS certificate from the Arizona Department of Water Resources, or ADWR, before marketing lots to buyers. Without this certification, the Arizona Department of Real Estate, ADRO, will not approve the subdivision's public report. Commercial properties located outside of AMAs rely on a combination of groundwater and surface water rights. Under ARS Pisreguar 45, Chapter 1, surface water rights are governed by the doctrine of prior appropriation, meaning first in time, first in right. This legal principle, established in Arizona case law, such as in Re the Rights to the Use of the Gila River, 2000, grants senior water users priority during shortages. For commercial properties, such as farms, resorts, or industrial facilities, dependent on irrigation or landscaping, understanding water rights is crucial for determining long-term viability and regulatory compliance. Closely related to water management is the issue of zoning classifications, which define how land may be used within a jurisdiction. Zoning is enacted at the municipal and county level under ARS Title 11, Chapter 6, for counties, and ARS Title 9, Chapter 4, for municipalities. Zoning classifications in Arizona generally fall into broad categories: commercial, C; industrial, I; residential, R; and mixed use, MU, each with subcategories that specify density, height, signage, and parking requirements. For example, in the city of Phoenix, a C2 zoning designation allows for general commercial uses such as retail and restaurants, while a C3 designation permits more intensive uses, such as car dealerships or warehouses. Understanding zoning classifications is critical not only for determining permissible land uses, but also for identifying the need for rezoning, variances, or conditional use permits, CUPs. A variance may be granted by a city's Board of Adjustment if a property owner demonstrates undue hardship caused by the zoning ordinance, as upheld in Pawn First, LLC versus City of Phoenix, 2016. In that case, the Arizona Court of Appeals confirmed that local governments have broad discretion to approve or deny variances based on consistency with the city's general plan. Commercial developers and investors often face challenges when property boundaries cross multiple zoning districts, or when parcels require rezoning to accommodate new uses. For example, converting an old industrial building in downtown Mesa into a modern office space may require rezoning from I2, light industrial, to C2, commercial, and adherence to updated parking and signage codes. Real estate licensees representing clients in such projects must be familiar with local zoning codes and should advise clients to consult with land use attorneys or municipal planners early in the process. Another regulatory consideration involves environmental compliance, especially for properties involving water or soil use. The Arizona Department of Environmental Quality, ADQ, oversees pollution control under the Arizona Environmental Quality Act of 1986, while the EPA's Clean Water Act, CWA, governs discharges into navigable waters. A commercial developer planning to grade land or construct drainage facilities may need a Section 404 permit from the U.S. Army Corps of Engineers. Failure to comply with these environmental regulations can result in fines, project delays, or denial of building permits. Together, these regulatory aspects, water rights, zoning classifications, and environmental compliance, form the foundation of lawful commercial development in Arizona. Real estate licensees who understand how these laws interact can better advise clients, anticipate challenges, and protect against costly missteps. Review summary. Water rights and zoning laws are among the most significant regulatory concerns in Arizona commercial real estate. The Groundwater Management Act ensures sustainable water use through AMAs and INAs, while zoning ordinances establish lawful land uses and density limits. Developers must navigate both systems to obtain permits, secure financing, and ensure compliance. Knowledge of environmental regulations adds another layer of due diligence that helps prevent liability and project delays. Understanding these interconnected elements is a hallmark of professional competency under AAC R428-1101H, which requires licensees to act within their areas of expertise. Discussion prompts. Why must a developer in an active management area obtain an assured water supply certificate before selling lots? Answer. Because it guarantees a 100-year sustainable water supply, a prerequisite under the Arizona Groundwater Management Act for ADRI to issue a public report. What is the difference between zoning and a conditional use permit? Answer. Zoning determines the base, permitted uses of land, while a conditional use permit allows specific exceptions within those zones under special conditions. How does the first in time, first in right principle affect water use during drought conditions in Arizona? Answer. Senior water rights holders retain priority access to water, while junior rights holders may face restrictions or suspensions during shortages. Closing remarks. The regulation of commercial real estate in Arizona is an intricate balance between economic growth, environmental protection, and public welfare. Water rights dictate the feasibility of development. Zoning controls dictate how land may be used, and environmental laws ensure sustainability. For licensees, mastery of these regulatory frameworks is not merely academic. It is a daily professional responsibility that shapes how deals are structured, developments are approved, and communities evolve. A well-informed licensee not only safeguards client interests, but also contributes to Arizona's long-term vision of responsible, sustainable growth. Supporting sources and key case law ARS. Title 45, Arizona Groundwater Management Act, ARS. Paragraph 45, Chapter 1, Surface Water Appropriation and Rights, ARS. Title 9, Chapter 4, Title 11, Chapter 6, Municipal and County Zoning Authority, AAC, R428-1101H. Standards of competence in specialized real estate areas. In RE, the rights to the use of the Gila River, 201 Rs or 307, 2000. Clarified priority of surface water rights. Pond First, LLC versus City of Phoenix, 242 Rs, 547. Appers, 2016. Established standards for granting zoning variances. Arizona Department of Water Resources, ADWR. Guidelines for Assured Water Supply Program.